Good afternoon and happy Friday. I just want to welcome you and thank you for attending today's webinar. My name is Beth Overmo. I'm the Strategic Plan Coordinator with the State Bar. Just wanted to let you know that the presentation will last about 45 to 60 minutes, and there will be time at the end for questions from those who are attending. So you'll have an opportunity to submit your text questions to today's presenters by typing your questions into the chat or question pane on the control panel. You may send in your questions at any time during the presentation. I will be collecting those and I will address them during the Q&A session at the end of today's presentation. And with that, I will turn it over to today's moderator, Aaron.
Thanks, Beth. Appreciate it and appreciate all your help and your work putting this together and having this webinar put on. Good afternoon, everybody. Hope you're all staying safe and sane on a Friday afternoon during these interesting times. Today's topic, we believe, is a good one. My name is Aaron Galloway, and I'm an attorney with the law firm of Lynn Jackson Schultz and LeBrun. I'm in our Rapid City office. I've been out here with the firm for approximately 7 years. And my practice areas are primarily business transactional, as well as real estate work and intellectual property work, helping business clients and individuals with copyrights and trademark law. And so we've got 3 great panelists here today, as Beth had mentioned, and so I'm going to go ahead and let them introduce themselves, and then we'll get started with the questions. So we'll go with Jennifer first, then Alex, and then Joe. Jennifer?
Thanks, Aaron. My name is Jennifer Frank, and I'm an attorney also with Lynn Jackson Schultz and LeBrun in the Rapid City office. I've been an employment attorney for about 23 years now, and before that was in human resources. So I've dedicated my entire career to pretty much helping employers with their day-to-day employment issues. Here at Lynn Jackson, I focus my practice on representing employers in employment law, all different topics. Sometimes I'll represent employees, and then I also help healthcare entities with healthcare law and do a little bit of school law as well. I look forward to talking to you today about some COVID-19 and related laws.
Thanks, Jennifer. Alex?
Thank you very much. This is Alex Hallback. I'm a partner with Cutler Law Firm in Sioux Falls, South Dakota. I've been practicing now for, coming up on 10 years now. And my practice area focuses primarily on business and corporate law, real estate and intellectual property law, and then a small percentage, small but growing percentage of my practice is for divorce and family law matters for divorce clients that have high net worth and have businesses that need to be divided as part of their divorce. So though I feel like I've spent the last 2 months of my practice, though, advising businesses on PPP loans, on tips and tricks to try and get them through these difficult times with COVID. Some business advisement on cash management. What remote work environments could look like, what technology is available, and I look forward to discussing some of those topics a little bit more with the group today. So thank you for the invite.
Terrific. Thank you, Alex. Joe, go ahead.
Thank you, Aaron, and Jennifer, Alex, thank you also for participating. Looking forward to the conversation today. My name is Joe Dilla. I am a vice president and legal manager at the First National Bank in Sioux Falls. I've been kind of in-house counsel with the bank for the last 4 years, just over 4 years. Spent close to 5 years in private practice prior to joining the bank, both at Banks McCullen in Rapid City and then at Cutler Law Firm with Alex in Sioux Falls. So looking forward to the conversation today. Thank you again.
Great. Thanks, Joe. Okay, so I think with our time frame here, we'll just dive right in and to let all of our listeners know, I believe kind of the first portion of this will be more focused on Families First Coronavirus Response Act. And so the first several of these questions, we may have Jennifer as one of our panelists giving more of the answers. And then as we transition more to the CARES Act with the Payroll Protection Program and the Emergency Economic Injury Disaster Loans and some of those questions, we may hear more, or we will hear more, excuse me, from both Alex and Joe. So that's kind of how I think we'll break this down, but we'll get right into it. So first topic or first area with the Families First Coronavirus Response Act, the FFCRA, what are the questions you are most frequently addressing with clients and within your own company or firm, and what has been the most unique issue, if any, you've been asked relative to the FFCRA? Jennifer, if you want to go ahead and take the lead.
Sure. I'll kick this off, and thank you, Aaron. First of all, and many of you on the call may be already aware of what the Families First Coronavirus Response Act is. It is a federal law that was passed by the Department of Labor, expanding the FMLA, the Family Medical Leave Act, which is a federal statute. And the provisions that are under the FFCRA relative to employers are two sections on paid leave. One is called the Emergency Paid Leave Act, and the other is the expanded family and medical leave portion. So those are the two main components that employers should be aware of and have developed policies surrounding these two paid leave components. As to the most frequent type of questions that I've been getting, first of all, it's to draft policies as well as to draft applicable forms for employees to request these leaves. As you can imagine, there are specific reasons why an employee could be able to take either the emergency paid sick leave or the expanded family medical leave. But those reasons are fairly narrow, and there are certain eligibility criteria that employees need to meet, and they need to meet a specific reason. So a lot of the questions I've been getting lately are, people may be fearful of coming into the workplace because they're concerned that they may contract COVID-19. Does this entitle them to stay home with pay under FFCRA? That would generally be no, because the FFCRA reasons are very specific. So those are some of the questions I've been getting, as well as what exceptions are there. And I know we'll be talking a little bit more about some of the exceptions that apply later on. But those are what I've been getting lately.
Okay, and you talked a little bit about, clients and businesses having some uncertainty with their employees and being in the office or being in the workplace. So what are, as far as kind of intermittent leave, what are some of the circumstances where intermittent leave for an employee is deemed allowable under the Act, and when might it make sense?
Sure. And that's a great question. We've been getting a lot of those types of questions because it does relate to the fact that many employers are having their employers telework or telecommute if possible, and that mostly means working from home. So that might be something that the employer would like the employee to be productive and work from home. However, what's occurring for a lot of us who have school-aged children is that the children are at home because their schools are closed, and one of the parents needs to help those children, care for them. Basically, is what's listed under the FFCRA is caring for the child because the child's school is closed or their daycare is closed. So if the employee and the employer agree, the employee can work part of the day on work-related matters and then take the other part of the day to care for their child. and we would just allocate, this is paid work time to these hours, and these other hours are FFCRA leave time.
Okay.
One thing, Aaron, that I did want to point out is that this intermittent leave is available only with regard to taking care of the child, not when you're actually sick because you have COVID-19 or, you're unable to work because you have symptoms and are seeking a medical diagnosis. So that intermittent leave is available when caring for the child, and it is only if the employer agrees.
Right. Okay. Good to know. And is there any crossover with the paid sick leave and paid, the expanded FMLA provisions of the FFCRA?
Yes. One thing that's a source of confusion for the businesses and employers is the fact that there is a bit of crossover in terms of the reason why you could have an employee take the leave. Under the paid sick leave, one of the reasons is caring for your child. So you can actually take emergency paid sick leave to care for your child if the school or daycare is closed. And if you're a full-time employee, you get up to 80 hours, which is basically 2 weeks of the paid leave at 2/3 of your normal rate of pay. Then under the expanded family and medical leave, the reason why you would take that leave is for caring for your child because their school or daycare is closed as well. But the first 2 weeks of that leave is actually unpaid. So employees can choose to substitute the paid sick leave for the first 2 weeks of unpaid expanded family and medical leave. And then the expanded family and medical leave is up to a total of 12 weeks.
Okay. And just to pause here, Alex or Joe, I didn't know if either of you had anything that has been covered that you would like to add.
The only thing that I would say, and the questions that I continue to get from employers too, is just every one of these situations is so unique that there really isn't a one-size-fits-all approach to dealing with individual employee situations. I've seen some that have, kids that are home doing homeschooling right now. There's a lot of medical issues that have been brought to light with various family units and things like that. And so my advice to clients has been to just stay in regular communication with your attorney or your counsel on it to help work out some of those individual situations. And I'm sure that everyone on the phone has realized that as well, that this really isn't a one size fits all to every employee in every situation.
Yeah, that's a really good point, that it's not, it's not a static situation, that and we're all learning this, it's constantly evolving. And so that necessitates, advising our business clients accordingly on that. Jennifer, are you finding pretty much the same thing as well?
Yeah, there's a lot of unique questions, so I definitely agree with that, Alex. And what I always tell my clients, regardless of coronavirus or whatever we're being asked to advise upon, is that we want to try to the extent possible to be treating employees consistently for the same or similar circumstances. Although the unique situation may present itself, if something comes up and it's similar enough, we're trying to treat people equally and fairly. So we're trying to be as consistent as possible, even given some of these unique things that come up. I had a call the other day. The question basically was like, we're returning people to work. They've been furloughed. Some people don't want to come back. Some people say they have, that they are, predisposed to getting something, or they're fragile or something like that. And I just want employers to treat these situations as consistently as possible so that they're not receiving claims of treating this person differently than another person, and they're trying to develop some sort of rules that are consistent.
Sure, and that makes sense. And I guess dovetailing on, having that treatment of employees remain consistent, how does, Jennifer, how does the FFCRA relate to employees who are deemed, exempt versus non-exempt?
Well, the FFCRA doesn't really address that issue specifically, but I have dealt with that issue with multiple clients because under the Fair Labor Standards Act, which is another federal statute, and the abbreviation there is the FLSA. The FLSA talks about exempt employees versus non-exempt employees, and it's basically the non-exempt employees are paid hourly, and exempt employees are salary basis, paid on a salary basis, and they are exempt from the Fair Labor Standards Act. But the difference there is that, like we talked about intermittent, taking this FFCRA leave intermittently, it's very easy to do with a non-exempt employee because they're paid by the hour. And so we can say, all right, Jennifer worked 3 hours, and she makes, $10 an hour, and she worked 3 hours for the employer, so that's $30. But then she took FFCRA leave for the remainder of her workday, which was 5 hours. And so we're going to attribute that to the FFCRA. So that works nicely with the non-exempt employee. But with exempt employees, under the Fair Labor Standards Act, they are paid a salary based on, really regardless of how many hours they work or even the quality of their work. They're just paid their salary. And so it's really difficult to have an exempt employee also on FFCRA unless that exempt employee is performing absolutely no work in the particular work week.
Okay, so then what are kind of the tax issues or tax concerns? So are there tax credits for wages paid to employees under the FFCRA?
Yes, that's a great question, Aaron. And what I tell employers who may want to claim that they're exempt or exempt certain of their employees where permissible is I tell them, don't forget though, if you do pay FFCRA paid leave, you are eligible to get a tax credit. And the tax credit is the employers will receive credit in the full amount of the qualified sick leave and family leave wages that they've paid, plus any allocable qualified health plan expenses and the employer's share of Medicare tax for the paid leave that they pay. So they basically get it back. So there isn't necessarily a downside other than, the employee isn't working because they're taking this leave.
Right. Okay. And then just to wrap up the final question or a couple of questions on the FFCRA, are you, Jennifer, getting questions from clients regarding the exceptions under the Act, like the small business exemption and healthcare provider employee exclusion, and how those are defined, and if you've got clients that may fit into that exemption or exception?
Yes, and that is another area where I've had probably a majority of my clients fit in, asking questions about these exclusions or the exemptions. We have a lot of small businesses in South Dakota, and under the FFCRA, if you are a small business, which is defined as having fewer than 50 employees, you may be able to claim that you are exempted under the small business exemption if providing the expanded family and medical leave or the portion of paid sick leave where you're caring for your child because their school or daycare is closed, if providing that leave would jeopardize the viability of your business as a going concern. So they would, they meaning the businesses, would have to evaluate whether providing and paying for that leave, even though they would get the credit back, if it would, result in their expenses and other financial obligations exceeding what their anticipated business revenues might be, and cause the business to cease operating. I've had questions from employers who were concerned that they would have to close or fold if they actually had to provide this leave. And so luckily there's this exemption for the small businesses. The other exemption or exclusion is how it's listed is for employees of entities where those employees can be deemed healthcare providers. And it's a fairly broad definition. Anyone who works, anyone who is employed. They don't have to be a doctor or a nurse. It's anybody who's employed by an entity such as a hospital, doctor's office, clinics, medical school, nursing facility, retirement home, all these different types of entities. All of their employees can be considered healthcare providers under the FFCRA definition, and so then the employer can choose to exclude all of them from coverage under the law.
So if an employer ostensibly would be deemed to fall under one of those exceptions or exemptions, is that kind of an all or nothing proposition? Can they work with their employees under the exemption in some cases and not others, or how does that work, or are there even any guidelines on that?
Well, I think that's a great question, Aaron, because I have actually been asked that by clients and help them to work things out in a way that works for their particular business. The reason I think it's important for any business to understand the reason for this exemption, and it is because, our healthcare entities are considered essential services, and they really need their employees to be there caring for patients in those particular types of entities. And so realizing that those employees may be needed there on the front line working is why the Department of Labor carved out this exception. But yes, they can decide that they will not provide the expanded family leave, but that if somebody were actually sick with COVID-19 and fell under the paid sick leave, that they can choose to provide paid sick leave, but maybe not the expanded family leave. The other thing I've advised clients is if you're going to kind of slice and dice this, make sure that you are treating the same category of workers similarly and not, saying, well, Jennifer can have paid sick leave, but Aaron can't. So that way we're not focusing on the individual, we're focusing on the job role. Right,
good. Okay, that makes sense. Appreciate that. Switching gears just a little bit here, I think all of us working have now become more comfortable, or hopefully with kind of telecommuting or teleworking. So these next few questions, certainly with our panelists, Jennifer and Alex as well. So start with Jennifer, and then Alex, we'll certainly have you chime in and give your perspective here on these questions. Have you advised on any telecommuting or teleworking agreements between employers and employees, and kind of what do those look like from a practical perspective, and including important provisions? So Jennifer, if you want to go ahead, and then Alex, will have you jump in on anything you have as well.
Sure. Thanks, Aaron. Yes, I've been asked to consult and advise on these telecommuting agreements, as well as just broadly like telecommuting policies. Not every business actually has an agreement, but I would recommend that if you have any teleworkers who are working remotely, that an agreement actually is very important. The telecommuting agreement doesn't have to turn an otherwise employee at will into a contractual employee, but what the telecommuting agreement does is it outlines various, terms and conditions of that telecommuting arrangement. and just really, proactively addresses some of the issues that can occur when you're having people not in the workplace, but that are working for you. So the important provisions are, what they have to do, how they're supposed to communicate what they're doing, how frequently they have to report in to their boss about what they're doing. I also think that one of the really important provisions is laying out the scope of their work, their office or their working area, because workers' comp still does apply wherever the employee is working. And so we want to specifically designate what section of their home is their actual working space. Also, we cover visitors, because there's still confidential information. If you're working for a healthcare company, you might be dealing with HIPAA, different confidentiality concerns. We don't want, family members barging into the work area or disrupting or, inadvertently seeing confidential information, that sort of thing. So those are some of the important things to address.
Right, great. Alex, let's get you in on this. I imagine you are getting these same sort of questions and advising on the same issues. So kind of from a practical perspective, what are you seeing, and I guess what are some of the major issues that you're having coming up and advising on, either the employee side or the employer side?
Yeah, I think, Jennifer touched on some of the big ones that obviously we're addressing on a kind of an individual basis. What we've seen in a lot of situations also is that employee handbook has a lot of confidentiality provisions in it that we can kind of use in conjunction with some sort of a telecommuting or teleworking arrangement with employees. I think it's really important, and what this issue has really prompted is for some of my clients to go back and look at those employee handbooks and what provisions should be or should have been included in those handbooks when they got kind of started. Again, covering confidentiality, remote working environments. I think it's important to note that the FSLA standards still apply. For instance, non-exempt employees punching in and punching out or recording time as they would have before. What does that, as Jennifer mentioned, how often are they supposed to check in with their supervisor? What is the expectation for work product, response time, access to technology? One of the other things that we have been trying to address is obviously the need to, if we're going to have expectations that employees work from home, what does that mean for providing equipment for that employee? And is the business equipped to handle it? Do they have the technology in place to issue out to those employees if they don't otherwise have access to it at home? Where is sensitive work information stored? Because there are lots of, in a past life, I was a network administrator. And so coming at this from the technology perspective of trying to advise clients on the multiple different ways that their employees can telecommute, whether that's a VPN connection, some sort of a remote desktop connection. And that becomes an important distinction because of where that confidential information or where that work product actually lives in that telecommuting environment. Does it live on a workstation or on a computer that is owned personally, or does it remain on an employer or on your employer's server and network? So understanding those distinctions as far as what is allowed and not allowed, from saving documents, emailing in for work product and information to yourself to a personal account. Jennifer touched on having family members accessing some of those shared resources and what they may have access to that they wouldn't otherwise have access to. And again, I can continue to come back to advising and attempting to direct clients on this really is an individual type of representation, because what may be for Jennifer remote working or telecommuting, what that might look like with her laptop, personal laptop, might be completely different than for instance, Aaron or Joe with a company issued workstation, antivirus protection is really important. Again, encryption on the employer side and on the employee side. There's just a lot of issues that have to be addressed. And I think setting those expectations up front with that employee in some sort of a written policy or an agreement that everybody signs is really important.
Yeah, that's a really good. Go ahead, Joe.
Oh, sorry about that, Aaron. I just wanted to jump in here and provide a little bit of perspective from my employer, who's a bank and a larger organization than most law firms here in South Dakota. So just kind of a practical situation that, we've gone through in this whole transition. We've got about 80 to 85% of our workforce that's now working remotely, and that takes a whole lot of different forms, like Alex was indicating. Some of those people have bank issued workstations or laptops, but I'm actually logging in through some, and I'm not a tech person, so I don't know exactly what it is, but it's essentially a portal. I think it's a VoIP portal where I can access my desktop at work remotely, essentially, and then everything is saved there. So we've kind of got like a hybrid going on based on, like Alex was indicating, just the number of machines and resources that we had available. And to Jennifer's initial point too, with the agreement, I assisted a little bit in getting something put together internally, and we weren't necessarily as formal as I think some other organizations were that just didn't necessarily fit our work culture and those sorts of things. But we did address a lot of those issues with, having to respond in, a same or similar manner, and it contacts with your direct superiors and direct reports and all of those sorts of things, essentially indicating that was going to continue as normal and reaffirming that all of our in-person policies, aside from dress policy, essentially still are in effect during this time. The one thing that I would say too, people that are like me in their setup where they're accessing remotely using their own computer, but may have wanted their second monitor stuff. We have permitted employees to take their second monitor home and link those up. So we did include in our work from home agreement, for lack of a better term, something to the effect of returning any physical property, tangible personal property, that is the property that belongs to the bank too. So just something else to think about there as well.
Joe, that's a good that's kind of a good background or synopsis, especially from a financial institution perspective. You heard Alex mention it, and I know Jennifer preaches it often in her practice, that a good employment handbook can be worth its weight in gold. And so, Joe, I guess my follow-up question to you would be, with the bank and having kind of a little bit of a hand in crafting the work from home agreement, did you find kind of what you had as far as the handbook providing, at least a decent basis for some of what you wanted to outline for the employees of the bank?
Yes, it did. So over the last several years, there has been a growing kind of work remote on an ad hoc basis where, for example, somebody's got plumber coming and plumber's going to show up at some point between the hours of noon and 4 o'clock. When you've got those huge time frames where we've just been able to allow people to start working from home in those limited circumstances. So we kind of had that to fall back on. And, to be honest with you, the agreement that we did draw up more or less just kind of incorporated either explicitly or by reference everything else that was contained in our existing employee handbook and employee policies. And then, for us, we've got a firm-wide, bank-wide online HR portal. So that agreement was just pushed out to everyone who has been working remotely, and required their electronic signature on that. So then it's documented on the backside as well.
Sure.
One of the other things that I just wanted to kind of bring up, and something that has been helpful now to flip into, if I put on my law firm management hat, our firm has always had a BYOD policy, a bring your own device policy, that employees acknowledge when they start with our firm. And so really our telecommuting policy and some of our information security provisions are really just an extension of that BYOD policy. So, one of the things that I encourage a lot of my clients, if they are allowing, a lot of times people don't want to carry multiple phones. That used to be the case. A lot of times you'd have your work BlackBerry and your personal whatever it might be, and a lot of that has merged into employees wanting to carry a single device, and really to make sure that it's, again, clear, that expectations are clear to those employees and to the expectations. Our firm has adopted and implemented a BYOD policy for all employees. So really this telecommuting and teleworking type of relationship that we have with our employees is just also an extension of that BYOD policy.
Great. No, that's a good point. Before we move on to the other portion of this presentation, kind of question and answer session here, I just wanted to ask if any of the three of you, Jennifer, Alex, or Joe, anything else on that you wanted to mention about the FFCRA or work from home or telecommuting? Understanding we may have some questions at the end, but just before we moved on and kind of switched topics, if there was anything else anyone would like to add.
I have one quick thing. I think you're seeing this reported a lot as well, but even just from my own personal experience here with, being in-house in a bank and having kind of a more traditional be at work culture, but now all of a sudden being thrown into this new reality, and the ability for an organization of, roughly 275 people to pivot fairly quickly and allow, like I said, 80 to 85% of our workforce work remotely. I do think that moving forward, work from home, work remotely is going to only become more and more prevalent and likely accelerate, even more so than it was pre-pandemic. And businesses just need to be ready for that. And I guess I would be interested to hear if Alex and Jennifer agree.
Yeah, that's a really good point. It's something that maybe you can't put in the box after this has kind of become somewhat of the new normal. Jennifer, Alex?
Yeah, I belong to SHRM, which is a National Society for Human Resources Management, and we get daily emails, and I'm also on other employment listservs, and this topic about the new normal is definitely one that's been being put out there. As this telecommuting environment we see now may actually go on post-pandemic, and it actually probably benefits employers and employees alike, just trying to find ways to work that in which the business interests and the employees' personal work-life balance interests are taken into account.
Yeah, I think the big what I'm seeing both with the firm and with some clients is that they're starting to see that it's entirely possible that a work from home type of arrangement could be more productive than what they were before. Sometimes there's less distractions at home. You're more comfortable. You can be more focused. So I think there are some clients of mine that are seeing some unexpected mixed results, both positive and negative in this new work from home environment, such that I think that there are some of the employers that I advise that will probably be implementing some version of this on a regular basis going forward, whether it's week on, week off. They're starting to see that they can utilize employees remotely and maybe not incur some of the overhead costs with larger office spaces and things like that. Now, I realize that this is a very micro scale of a couple months, really a trial period, but it's prompting some much larger conversations for them to figure out if this is something that they could entertain going forward on a more permanent basis and potentially reduce their physical footprint as a result of it.
Yeah, and that really is interesting, and I think you'll see that come up with employers, irrespective of size, from small to maybe medium-sized companies, including the larger ones. I mean, it's kind of that saying that necessity is sometimes the mother of invention. So what this will look like on the other side long term for the employer-employee relationship. So that's all great comments and great input from all of our panelists. Switching gears here a little bit to the back portion of what we wanted to talk about today. Under the Coronavirus Aid, Relief, and Economic Security Act, which we all have lovingly come to know as the CARES Act, two of the more talked about programs obviously are the Paycheck Protection Program, the PPP, and the Emergency Economic Injury Disaster Loans, EDIL. So the PPP and the EIDL, I think the PPP has obviously gotten the most press and probably brought with it the most questions as it continues to literally evolve in what's required under that program of the CARES Act. So, Joe, I guess we'll start with you, and then obviously, Alex, have you give us some of your perspective on this as well. But Joe, with being with the bank, I assume an SBA 7A qualified lender, what are some of the kind of the questions you've been getting over the past several weeks from customers and clients as to the applicability of these programs to their needs?
Sure. Yeah. I mean, PPP originally started at the end, or at the beginning of April. Excuse me. I think the first active day was April 3rd, and it started with $349 billion in funding, and that ran out about the 17th of the month, and then we started back up on the 23rd with an additional. I can't even remember the new amount, but anyway, we've kind of had two phases of PPP, or at least that's the way that we talk about it internally, is the two phases. I think it's fair to say that the first phase was truly kind of a gold rush situation, and everybody was building the plane as it was heading down the airstrip, and just doing the best that they could with the limited information that was available. This second phase seems to be working at a much more manageable pace. Specifically for our organization, we've seen it's not nearly as busy, and the majority of the applicants that we're seeing now are sole proprietorships who are seeking funding. A lot of the larger organizations, they had the attorneys from Lynn Jackson Cutler, all of the law firms, whoever it is, but they had that long-standing relationship with an existing law firm or an accounting firm, whoever, that could help them kind of sort through the intricacies and figure out what exactly they needed to do. But I would say the biggest question that we still get and we still kind of grapple with from time to time is, am I eligible? If you're eligible, it's really not a too difficult process. You complete the application, you provide the additional paperwork and verifications, and you're good to go. So if you are an eligible entity, I do think it was fairly straightforward, as long as you could marshal all of the other information that was required. But just the basic question of, am I eligible, is still the question that we get most of the time. And again, back to what Alex and Jennifer talked about at the beginning, it's a kind of a one-by-one analysis. You have to go through, do they meet these criteria? Is it a faith-based organization? Because there's special guidance as it relates there and everything else. But I would say that's the biggest question that we continue to get.
Okay, Alex, what are you seeing or hearing from clients, just kind of at a 40,000 foot level with the PPP or the EIDL, if that's applicable?
Sure. I think most of all, I kind of look at it as phases of conversations with clients. The first 2 weeks, there were a lot of tears of realizing that they were shut down, or they were forcing to shut down, or they needed to shut down, and trying to figure out how they were to pay rent and pay their employees and pay for expenses. And so with my clients, the first couple of weeks were a lot of tears. The PPP program and some of the EIDL, maybe a little less so with my clients, but those gave hope to them that they could try to survive this and make it through. I think, again, my recommendation, and I think Joe touched on this and hit some of the high notes of this, but with my clients, it was get prepared and ready to file as soon as the program opens, because I knew that money would disappear, and it would disappear quickly. So I think I assisted probably 15 or 20 clients with PPP applications. Thankfully, it was a pretty easy application, pretty streamlined. There aren't a lot of representations or specific financial disclosures, eligibility requirements for guarantors and things like that. And I have to hand it to a lot of the local, smaller community banking organizations. They seem to be almost more equipped or more willing to, do what it took to get these small businesses those loans to participate. Now, there's a difference between the EIDL dollars and the PPP dollars. The EIDL loans were really direct loans with the SBA, and the PPP loans were through participating community banks or participating lenders. And again, banks like First National Bank in Sioux Falls really stepped up and did what it took to get those loans through. This next round, I think, again, the biggest question that most people are getting is, am I eligible? And how do I calculate the payroll amount? How do I calculate the benefits? How do I exclude those with a salary over $100,000? And the other thing that I've looked at is each bank is somewhat addressing certain of those questions differently and are calculating things differently. And I know that they are doing the best they can based on guidance being provided by the SBA. But that's something that I'm still somewhat seeing as just the differences in bank interpretation of the regs.
Sure. And I guess as kind of a follow-up on this, for those clients, and Alex, I guess I'd come back to you first, for those clients that you have worked with or have advised under either the PPP or the EIDL, is it your understanding? I mean, are the program monies helping them as intended? Do you have any understanding of that, or what are some of the major pitfalls that you were finding for that business was having for either qualifying or utilizing the money lent properly under the program?
Now, the biggest thing that I'm seeing now is a utilization problem. And the program is really based upon payroll dollars, right? So your loan amount is a direct product of what your payroll was. It doesn't look at what is your rent expense, what is your mortgage payment, what are your utilities like. And the thing that I'm seeing is there's a wide swing of how those dollars are and can be used from various businesses. I have one client with a rather large monthly rental payment. Their rent and utilities approaches $40,000 a month, but their payroll is not very significant at all. And so as a result of that, their eligibility for PPP funding was probably less than what I would have liked to have seen it. But they can only use up to 25% of those PPP dollars and still be eligible for forgiveness. They can only use up to 25% of those PPP dollars for rent, utilities, mortgage payments, etc. The remainder, the 75%, need to be used for payroll. And there's this balancing act between leaving employees on unemployment and or bringing them back, paying the payroll expenses essentially to have them do very little or nothing if you can't be open. Now, I've seen some really creative businesses that have pulled employees back, have got them back on the payrolls, and they've really tackled some major projects that they've had for, some of them up to 5 years of major projects that have been backlogged, but they haven't had staff time to devote to those types of projects. Well, now with their business closed, they can use those payroll dollars to retool, to expand some offerings. And I think those businesses that are getting creative in how to put those employee hours to work are those that are really going to be poised to be super successful once I keep referring to it as the lifeguard blows the whistle and we can all go back swimming again. But I think they're going to be in the best position to really be successful after we're through this.
Alex, that's a great analogy there with the lifeguard blowing the whistle. Anybody growing up, especially public pools in the Midwest, knew as a kid you waited for that whistle to blow, and that's kind of what the country's doing. So that's great. Joe, anything to add? I kind of wanted to ask this question. It's a little bit more specific, but the application, especially for the first round under the PPP, was relatively straightforward, and I know that you and Alex have both mentioned that. But this, and distill this down, it's a loan application, it's a loan process with the availability of forgiveness of a portion or all of it, essentially turning it into a grant. The SBA is updating its frequently asked questions pretty much weekly, and one of the updates of last week, I think last Wednesday, was if you filled this out and you said that and you certified in your application that you needed the loan monies because of uncertainty, now in order to be eligible for any of that forgiveness, it's you're going to have to show a necessity and be prepared to bring receipts. So is that something that you're seeing as an evolution here, and as a financial institution, on what that looks like? And then I guess I'll follow up with that question to Alex on what he understands that to be as well. But Joe, go ahead.
Yeah, I mean, I think it is, like we talked about, it's an evolutionary process here, and things are changing on a daily, if not more frequent basis with a lot of these programs. And one of the things that my bank, my employer, has been concerned about from the beginning is, what does it look like in order to get the forgiveness on the back end? And, we've spent a whole lot of man hours in the last 5 weeks, 6 weeks, just getting ready to get these applications done. And now that is starting to slow down and we're not seeing as much traffic there, we're reshifting our focus to that to hopefully assist the borrowers who did obtain a PPP loan through the bank in getting that completed. Honestly, I don't know what it's going to look like at the end of the day, but I do think there's going to be some sort of, show us the receipts as to where all this went before it's fully written off and forgiven. I don't see it being any other way, because if you don't do that, there's obviously the concern that, a group of owners or a single owner walks away with some sort of windfall here. So I think that there's going to have to be some sort of more comprehensive documentation of the forgiveness part. But what that looks like exactly at this point, I honestly don't know. And quickly, sorry, Alex, to throw you off, but I just wanted to mention with the EIDL, it was indicated that those were the direct SBA loans. Those or not even loans. They didn't have to be repaid at all. But the funding, the appropriations for those did lapse end of last month. I thought I had a date here at some point. It looks like 4/24 of 2020 those lapsed. So there are no longer any funding or appropriations for EIDL.
Mm-hmm.
Okay.
Go
ahead, Alex.
Just the one recommendation that I would add, and what I've been telling all of my clients to kind of follow up with Joe's points of, essentially show us the receipts. What I've advised clients to do is set up a separate checking or banking account, have your PPP funds, loan funds or PPP dollars deposited into that separate checking and/or savings account. And then when there's a qualified expense that's paid, just make a transfer or write a check from one checking account to your general operating account to pay for that expense. For instance, if your biweekly payroll is $4,280, transfer, and it's a qualified payroll, eligible for the PP to be used from PPP funds. Now make that $4,280 transfer from your PPP account into your general operating account. Staple your payroll along with a transfer, a printout of the bank transfer to that payroll report, so you have all of the documentation ready when the banks come asking for it. I think that's the easiest way to keep track of it, and at least that's been my recommendation to clients who are receiving those funds. I think looking, again, bigger picture here, I think the banks, again, those local community banks did a really great job of getting the dollars out, but they are ultimately going to be the ones that are left holding the bag if it's determined, I think, at some point in the future that the repayment isn't what some of their borrowers thought it would look like, and those aren't eligible for forgiveness. The bank is going to be, I think, on the hook to try and figure out how do we get those dollars back from those borrowers if they're not eligible for forgiveness. And Joe, maybe you have some guidance on that, but I have tried to tell clients to be really careful, really mindful, and account for every penny of those PPP funds that they're spending.
Alex, that's a good point, especially avoiding, any sort of commingling issues of funds that a business may procure through the program. Joe, any follow-up on that?
No, I would say the separate account is a really good idea. And yeah, candidly, that the community banks or any financial institution, if there isn't forgiveness here, there is concern about what did we sign up for and what are we on the hook for if these things aren't forgiven, and if they're not forgiven, does the borrower have any ability to repay, given the flux and uncertainty in the business arena as it is right now, and lack of collateral, like you mentioned before, with lack of personal guarantees and anything else that we would normally plan to obtain in making a commercial loan. So that's a concern, but I do think, it's like anything else. The more you can document and show, the easier it's going to be. That's the easier it will be for the banks, and I think it'll make it easier for the businesses as well.
Okay, that's a good follow-up point as well. Well, we're nearing the end of our hour here, and so I want to keep us at least somewhat on schedule. So I think what we'll do here is just have with the three of you as panelists, anything that you'd like to share or circle back on with either the CARES Act or with the FFCRA as far as success stories or tips or tricks that you'd like to share. So we'll, Jennifer, anything to add?
Sure. Thanks, Aaron. Just to wrap up, I thought of a few additional things that, we're talking about businesses, but we're talking about these businesses as employers and what they can do for their employees in these challenging times, even if they have to end up furloughing or laying off employees. So a few things that I thought of: I've had clients who are paying employees bonuses for actually working, if they're working especially in jobs that are a little bit more high risk, dealing with the public, dealing with patients, dealing with elderly people, so forth, paying them hazard pay, recognition, some sort of recognition or award, because employee engagement is very important. Employers can allow employees to utilize their accrued paid time off or other form of paid leave, even if they're not eligible for FFCRA leave, or even if the employee is furloughed, and in that way getting a continued payment stream for that employee so they're not placed in an undue hardship situation. somebody mentioned, unemployment. We haven't really talked about unemployment, but there are expanded COVID-19 unemployment benefits here in South Dakota. We call it reemployment compensation. So there are some enhanced benefits there that if an employee, even if their hours are reduced, they could apply through the South Dakota Department of Labor for those expanded benefits. And then finally, maybe even making employee assistance plan benefits greater, or at least known to employees, because employees are not only trying to do their work in a new environment, as we've talked about, but we are also seeing employees struggling as human beings with, lack of social interaction and, just taking care of everyone's mental health. So making those employee assistance plan benefits more well known. So those are my additional thoughts, Aaron.
Okay, great. Thanks, Jennifer. Joe?
No, nothing more from me. I appreciate the conversation. Thank you all.
All right, great. Thanks. And Alex, I'll give you last word here if you want it.
I guess I'm just gonna, I brushed off my soapbox and I'm gonna step onto it here for just a second, and just say I think the biggest thing that I've tried to relay to clients and just to people as they're going through this is an extremely stressful and difficult time. The issues are changing on a daily, sometimes hourly basis, and if everybody can just give the people that you're working with, coworkers, colleagues, other professionals, just some grace in dealing with some of these issues and trying to work through it, I think we would all be in a little bit better spot. I know that tensions have really run high, oftentimes, and continue to run high. But I think if we can just take a deep breath some days and remember, we're trying to all get through this together, doing the best we can, I think it would go a long ways. So thanks again for including me on this panel, and I wish everybody the best of success in trying to help their clients and deal with their own business issues. So.
Alex, I think that's great advice, not just legal advice, but just on a basic human level. So that's wonderful. I want to thank our panelists here today, Jennifer, Joe, and Alex, for making the time. I hope you all stay safe and sane. Like I said before, these are very interesting and unique times. I know we may have some questions, further questions for the panelists. So at this point, I'll step back and give it back to Beth. Thank you.
Thank you, Aaron. We actually have no questions. If you do have questions following today's presentation, feel free to email them to me at elizabeth.overmo@sdbar.net. Once you leave today's webinar, you'll receive a survey on the presentation, and we'd appreciate your feedback. You'll also receive a follow-up email within 24 to 48 hours with a link to view a recording of today's program. And so on behalf of the State Bar of South Dakota, thank you for joining us today, and thank you to our presenters for sharing their expertise. Have a wonderful afternoon.